All right, good afternoon, everyone. Welcome to our second in a series of webinars on avoiding common mistakes in federal construction contracting. This one dealing with the mistakes that occur during project performance. We would ask that all participants be muted, and they are, I think, automatically upon entry. If you have questions, feel free to type them into the Q&A box, and we'll do our best to get to those at the conclusion. And the webinar will be recorded, so we will be distributing it afterwards, so you don't feel that you have to take a lot of notes. You'll be able to recall what we discussed. We have a lot of information to cover today. I will be one of the presenters. I'm Michael Payne, the chair of our firm's government contracting group. I'm being joined by my partner, Casey McKinnon, who is in our Washington, D.C. office and practices exclusively in federal government contracting, as does Steve Tobin, a senior counsel with a great deal of experience when he was counsel for the Navy. And he will be contributing. And we have Ryan Boonstra, who works with me in our Philadelphia office and also is exclusively involved in federal contracting. The point that we want to use as the theme of this particular presentation is that protecting your rights is the most important thing to remember during performance of a contract or of a project. This doesn't mean that you should be preparing for litigation or should become known as a claims artist, but there are certain things you have to do to make sure that you don't make some of the mistakes I'm going to point out today that can cause problems later if things don't go right. And one of the things that we've noticed over the years is that sometimes the contractors don't really understand the agency hierarchy. The contracting officer has the ultimate authority to bind the government. Understand that the contracting officer is the only one who really can sign on behalf of the government unless there's been some delegation of authority, which happens from time to time. So it's important, particularly if you're dealing with a military agency, to always respect the chain of command, even with the civilians who work in the military agency, and generally avoid going around them, but know the positions of the people you're talking to, the level of influence that they may have. You sometimes will be in a meeting and you have to keep in mind that the loudest voice may not necessarily be the person who is the decision maker. When I worked for the government, I often thought to myself, these contractors would be amazed if they heard what went on in the private meeting that the government has before and after the meeting with the contractor. The contractor may not realize that there are a number of people on the contractor's side. And conversely, the contractor may not realize that someone who's been silent or appeared to be friendly is arguing against him. But you can't necessarily figure all those things out, but understanding the hierarchy is important. And understanding the levels of authority is very important. Again, the change orders for the most part have to be authorized by the contracting officer. An ACO may have some authority, but it's usually a limited dollar value. A government inspector does not have the right to change the contract. And the end user who this particular project is being built for certainly doesn't have the authority to alter the terms of the contract. And what happens is many times contractors wanting to be cooperative, which is a good thing, and not rock the boat, will sort of give in to what people in the field are requesting be done. And if it's something that could lead to additional work, and particularly to additional expense down the road, you have to be careful not to do that. Because while it's fine to play nice, and it's fine to come off as a nice person, you can be taken advantage of by government people, and you might end up doing work that someone will say, well, you volunteered to do that work because you weren't authorized to do it. So keep that in mind. Now, the government has certain rights too that you have to be aware of. And Casey, please comment on that.
Sure. Thanks, Michael. In my humble opinion, this is the root of most of the frequent mistakes we see during project performance, and that's not understanding how expansive the government's rights are and how they differ in a number of ways from a private project owner. So the government has broad rights to direct changes, and a contractor has very little right to refuse those changes, unless they're a cardinal change that really alters the fundamental nature of the contract. In most cases, your option is simply to accept the changes and move forward and perform them. The government is required to be reasonable, but it doesn't have to be perfect. So we end up with, our clients are frustrated in some cases after a project because the government can make mistakes and still prevail in litigation. So it's important to remember that it's your duty to work with them. They don't have to be perfect in every case. And just because they're not perfect doesn't give you a right to refuse to perform or to unnecessarily fight with them on changes. And part of this all boils down to the public policy that lies underneath the FAR and the associated regulations that go with it. And the goal there is for the taxpayer to be protected. It's not a system that is designed for a contractor to be treated fairly. It's for the government and the taxpayer to be protected. So understanding that the FAR is set up in an uneven fashion can be helpful in understanding the situation you're working with. And one of the best examples of this is known as the Christian doctrine. It comes out of a case called GL Christian and Associates. It's been longstanding at this point. And what the Christian doctrine stands for is the proposition that if a FAR clause is required to be inserted into a particular contract, and maybe the contracting officer simply forgets or omits it for one reason or another, it's still read into the contract. And the reason that is because the taxpayers be protected by the existence of that clause, even if a mistake is made and it's not there. And it can lead to some rather unfair and inequitable outcomes for contractors. But it gives a good example of how the playing field is tipped in favor of the government taxpayer, and contractors are wise to understand that as they head into the contracting process.
Thanks, Casey. Now, you may notice that these various slides all have the word failure in the title. It's because as we thought about it, we thought, well, if we're talking about mistakes that contractors may make that can cause them problems during performance, most of the time it's as a result of the failure to do something that they could have done or should have done. So that's basically an underlying theme to what we're presenting here. And this topic deals with the failure to prepare a proper schedule. As you know, one of the first things the government wants on a construction project usually is a baseline schedule. And you know, you should have thought about it, and you better be realistic in what you present because your performance is going to be measured by it. Sometimes contractors are very optimistic about what they can do, and they will show an early completion date. Some agencies won't accept that because they say, no, we expect you to use all of the available time that the contract gives you. That's okay. If they really insist on you using all of the time in the schedule you submit, there's nothing wrong with you having your own schedule in-house that shows an early completion. And if you have prepared a realistic early completion schedule, you can show that it was done you know, not after the fact, but before you began work, and that it is the government that prevented you from meeting that early schedule, you may be entitled to additional time or money because of the government's interference with your ability to finish early. So keep that in mind. But the updated schedules that you're required to present should be done in a timely manner. They should contain narratives that explain what has happened. Some owners won't allow you to include delays from schedule updates because they're afraid that they're somehow conceding that the government was responsible for those delays. The only thing I can tell you is do things as accurately as you can. Don't be overly concerned about the resistance you might get from the government. The important thing is that the information that you record is accurate. And I'm sure, Steve, from a government's point of view, you've seen this issue come up.
Yeah, you're spot on, Michael. So look, with respect to this idea of the schedule is supposed to reflect the actual project's progress, right? And that many times, especially in the construction world, includes delays. So what we see sometimes is the agencies come in and say, well, wait a second, the updated schedule that you've provided us is reflecting a number of delays. Well, we don't agree with those delays. We're going to reject your schedule. You're going to have to go back and give us a schedule once you've excised the delays out. Okay, well, what that does is it kind of puts everybody in a bit of a logjam because one, it doesn't reflect the actual circumstance of the project at that point. And two, it creates a situation in which potentially there's two schedules, right? There's going to be a schedule that the contractor is using to manage the job, and there's going to be a schedule that they've created to essentially appease the owner. So you've got two conflicting schedules, and what I would recommend is really a dialogue with the agency and saying, look, our schedule reflects the delay, and it's there because the delay is real. But the question as to who is responsible for that delay is separate and apart. So, I think Michael alluded to in one of his comments earlier, have a schedule that reflects the reality of the situation. And then if downstream, if you guys have to resolve it in the dispute process, then so be it. But keep as much of the information up to date as possible.
Okay, thank you, Steve. And along the lines of what's done early on in a project, in addition to the schedule, is putting together the various submittals that the government requires. A quality control plan, a safety plan, whatever the case might be, an environmental plan. Some contractors don't take them as seriously as they need to, and then they run into some obstinance on the government's part because the government rejects them. And then you get into a battle about, well, was the rejection reasonable or not? Generally speaking, you should do your best to submit these things in a format that the government prefers. It varies not only from agency to agency, it may vary from district to district, for example, within the Corps of Engineers, from area office to area office. The government has time to review a submittal before they approve it, but it has to be a reasonable time. And you certainly can get compensation and time extension if the government takes too long to review a submittal or beyond the time that's allowed by the contract, particularly if they end up approving it and they could have approved it a lot earlier, or if they don't approve it and they should have approved it. So the preparation of submittals is important. And I've had counsels for the government from time to time say to me, Mike, if you want to give a seminar, a webinar to the contractors that would help us in the government, why don't you teach them how to prepare submittals? Well, I guess we could put up a program like that, but most contractors have done it enough that they know how to do it. It's the newer contractors that we find often get into trouble, particularly those that haven't dealt with that particular agency before. And along that, the next thing that happens is there can be a failure to emphasize and understand the implications of the quality control program. And Steve, why don't you talk about that?
Sure. And let's start with that bottom bullet point first, because I really think that's, the overarching point that really needs to be foot stomped here. Quality control is I know it says it should say extremely, it's extremely important to the government. And it's incumbent upon the contractors and really in everybody's best interest that you show you take it seriously. Okay. It's your quality control is essentially a substitute in a way for the government's inspection. They are relying on you to provide them with a product that meets all of their requirements, okay? And so the way to do that is to set up a robust quality control program. The government is absolutely entitled to insist on strict compliance. So even if you provide a service equally as good, or you think that whatever effort you've made meets the spirit of the contract, that's not good enough. The government by law is entitled to insist you meet the letter of what they've laid out in the specifications. Okay, approved shop drawings, they don't relieve you of your responsibility to comply with the specifications. Any quality control reports that you put together, so you want to submit them timely and you want to make sure they're thorough. You want to make sure that in the remarks section, you've detailed every step that you've taken to ensure the quality of whatever work you performed in a given day. And this next bullet point here with the contemporaneous documentation, this holds true across a broad spectrum of issues in government contracting. But here again, with quality control, which is a very important issue, you want to make sure you're documenting these things at the time they're happening. Because if things go south on your project, you want to be able to dig those documents out and show what you did on a given particular day, what you did for a particular element of work, And you want to make sure the government understands that reflects the reality of what happened on that particular day. So take it seriously and make sure you really document what work you're doing out there.
Good point, Steve. And, as Steve mentioned, contemporaneous documentation. What that means is documents that are created at the time the events or the actions occurred. In other words, if you're recording something in a quality control report, do it the same day. Don't go back and edit it a week later or something like that. Because if you ever have to testify about what happened in a project 3 or 4 years ago, and it's one thing to try to recall what happened. It's much better to say, well, no, I'm just not going on memory. I'm looking at what I recorded in a quality control report contemporaneously at the time that it happened, and that's refreshing my memory. Because let's face it, most people aren't going to have a very good recall of things that happened 3 or 4 years ago. And with regard to shop drawings, we see a lot of people getting into problems. The contractor sometimes will submit a shop drawing that actually does deviate from what the specifications require. But the government, either because they're lazy or because they miss it, they approve the shop drawing. And then you go ahead and do the work according to that shop drawing, and somebody else in the government looks at it and says, wait a minute, this isn't what we wanted. This is not acceptable. And you say, well, yeah, but I showed it on my shop drawing and you approved it. What's going to happen then is the government's going to say, no, the fact that we approved that erroneous shop drawing doesn't relieve you of your responsibility to comply with the specifications. And the government is going to win on that type of an argument. So be careful about that. Another thing that we've often told contractors is don't be afraid to admit that you made a mistake and to take some action in a quality control program that not only admits the mistake, but corrects it. When you submit proposals on a new project, many times you'll be asked to comment on quality control and what you've done in the past to demonstrate your ability to exhibit quality control. It's actually a good thing to say, we had a problem on a project 2 years ago where, and I'm just using a simple example, our workers were not wearing hard hats. And even though we told them to do it. So what we did about that is we brought in an outside consulting firm to give them a program on the hazards of not wearing a hard hat and why it's important. And from that point on, everyone understood and they took it seriously and we didn't have a problem again. Some people would say, well, why do I want to admit that I did something wrong? That's the wrong way to look at it. What you're doing is showing that your quality control program worked and that you took it seriously. It actually will get you some additional points in an evaluation. It won't detract from it. Okay. And then, of course, we get into the subject that comes up in many, many contracts, and that's changes. Things happen. No government set of plans and specifications is perfect. There always are things that were unexpected. There are always changes that need to be made. And Casey, you run into this issue quite a bit. So why don't you talk about this?
Sure, and it comes up most frequently during the disputes process. And most frequently, the factual scenario is that there was clearly a change to the contract, whether directed or constructive. And the question becomes, well, did anyone mention this to the government? And the answer at times is no, and it can be problematic in terms of pursuing your claims and disputes down the road. So when you run into a change, and we have two types of reference here. Directed would be a very clear directive from the contracting officer to do some additional scope of work or make some change to your scope. And then constructive would be not a direct instruction to do something, but something that is required to be changed nonetheless due to the circumstances or a differing site condition or something along those lines. But in whatever the case, it's incumbent upon the contractor to notify the government that what has occurred is a change to their contract. And it may be early on, all you can provide notice of is what the nature of the change is. And you'll have to tell them that down the road, I can provide you with an estimate of the resulting cost because I'm not sure at this time. But eventually you'll need to let them know that the change has occurred, your projected cost associated with it, and then the projected time impact associated with it, if that's the case. Because if you haven't provided that notice, it gives rise to a defense for the government that, well, no one told me about this. No one told me it was a change to the scope. If I had known there were cost impacts, I might not have made that change. and it can really harm your ability to pursue your claims down the road. Another point referenced here is to keep track of and segregate costs. So once that change has occurred, if possible, it's best to segregate those costs into a different line item or tracking number of some sort. So when the time comes, it's very easy to say, here are the man hours I associated with it. Here's the extra material. Here's the extra overhead. If you can segregate those costs out, it can make it much easier to deal with down the road. Otherwise, you're left trying to unwind those costs from all of your other project costs, and it can make proving your costs quite difficult. And the final point, most contractors are aware, but to the extent you're not, avoid allowing negotiating room. The False Claims Act does not allow a contractor to pad their costs or negotiate some additional costs in. If you're providing amounts for changes to the government, make sure they are actual costs, not negotiating room costs. And in avoiding that, you'll avoid False Claims Act allegations and avoid a whole world of trouble.
And that's right. Following up on that, Casey, you can't just submit a quote to the government. The government may say, well, we're thinking about some extra work here. We want to change the dimensions of this building, or we want to change the materials that are being used. How about giving us a quote on that, a price on that? And you do and say, okay, that's going to be an extra $100,000. And the government says, okay, that sounds reasonable. Go ahead and we'll get a change order to you in due course. Okay, you can take that directive as long as it comes from the contracting officer or someone with authority. But once you do that work, let's suppose you figured out a way to do it for $75,000, not $100,000. In the private world, you could say, to a homeowner or whoever, if you're a contractor doing a roofing job, hey, I quoted you X dollars and that's what I want to be paid. To the government, if you quoted them $100,000, you're entitled to an equitable adjustment of the contract under the changes clause. And that means that you are reimbursed the costs that you actually incurred, plus reasonable overhead and profit. So if it turns out that the number should be 75, not 100 as you originally surmised, then you could run into a False Claims Act situation if you tried to get the 100. Now, of course, the difference would be if the government issued an upfront firm fixed price change order and said, yeah, you're authorized to do this work, and the agreed upon price is $100,000. In the unusual case where it's really done that way in advance, then that's almost like a firm fixed price contract, and you'd be able to go ahead and do the work and still collect what you had priced to that. There is also, as Stacy said, avoiding negotiating room can cause problems. It's always bothered me because it creates sort of an irreconcilable conflict in the system. On the one hand, the contractors are told, if you allow yourselves negotiating room, we might change you with fraud if those numbers are unrealistic. But guess what? If the government believes that you have a meritorious claim for changes or defective specs or something like that, they're always going to try to negotiate you down. So there's downward negotiating room that the government's allowed to do, but there's not upward negotiating room that you're allowed to do. I don't have an answer to that, but I can tell you that the government generally prides itself, even if they feel a contractor is entitled to $100,000, getting that contractor to accept less than that in order to get the money now. Okay. Now, in any of these things we're talking about, documentation is one of the most important things we can tell you about, because if you don't have good documentation and you end up with a claim later, you're going to regret it. As attorneys, many times contractors will come to us. It may be when the project is nearly completed, or at least after the problem has been identified months previously. And they say, Mike, the government's not willing to give us any additional money. They say no change order, that whatever was spent here is our fault, and we need to put a claim together. All right, the first thing that we as attorneys are going to want to know, okay, well, do you have some documentation? When was the problem brought up? Was it recorded in your daily report? Did you write letters? Did you write emails? And many times we find that, a lot of it was oral, not too much was written down. That makes it very hard sometimes to prove your case. If you are writing letters or writing, in this day and age, mostly emails to the government, stick to the facts. Don't use purple prose. By purple prose, I mean, don't get very colorful in the way you describe the government employees. The outrageous conduct of the contracting officer, the obstinate contracting officer, the ridiculously stupid contracting officer. Don't use those kind of words in something that you write, no matter how true it may be, because that'll come back to haunt you and then possibly embarrass you in a trial. Don't refer to people in the government by their names, usually either. Don't say, John Smith, the contracting officer, said this. It personalizes it. Just refer to the people by their titles. We asked for this information from the contracting officer, and we were told the following. And that'll create a much better documented record. Photographs and video recordings are very important. Make sure the photographs can be authenticated. By that, I mean that you know who took the photograph. Hopefully it has a date stamp to show when it was taken, and then that someone can recall exactly what you were trying to show. And just like a photograph is worth 1,000 words, a video recording can be worth 1,000 photographs. Be careful when you're doing video recordings, though, because most video recording devices have microphones. So forget a running narrative that might embarrass you. Just describe what it is you're recording and trying to show, and leave it at that. And of course, in our electronic age that we're in now, email is perhaps the most dangerous thing there is, because it used to be when you got a little upset about something, you'd write a letter, and it would perhaps initially be written in longhand, going way back, or else typewritten and read and then mailed. Well, by the time you went through that process, you might have thought better of it and said, okay, I feel better that I wrote that. Now I'm going to crumble up that piece of paper and throw it in the wastebasket. With email, you type it, you hit send, and it's gone. And crumpling it up and throwing it in a wastebasket doesn't really happen. So be careful what you say in email, because email is always something that is disclosed in discovery. We'll get all the government's emails, and they're going to get all of yours. And be careful about email threads. Don't allow there to be a long thread in an email, particularly if that thread has things in it that are not necessary or don't deal with the subject matter at hand. We've run into clients who circulated pictures to one another in the office that weren't very nice. And then they shouldn't have been circulated in the workplace. And they end up showing as attachments in business emails that have to be disclosed to the government. Creates a lot of embarrassment. So be very careful about that sort of thing. But if you want to avoid going to trial on a claim, and believe me, even though as lawyers, that's the way we conduct our business, and that's what we do. We try cases when necessary. The best way to avoid it is through proper documentation, because if you can show the government that you can back up what you're saying, that's the best way to avoid a trial. And electronically stored information has become a term of art. So anything that you have stored on a computer system is going to be discoverable, not just email, CAD files, Excel files, Word files, PDF files, image files, all of it, even recordings, all of it is going to be disclosable and discoverable. So be careful. And also, be careful of handshake deals. We've seen cases where contractors have been asked to do work and they said, okay, we'll do it for you. And there's a handshake and no change order and no documentation whatsoever. And then the contractor has trouble getting paid later. I remember an admiral in the Navy, pretty high rank, went to a dredging contractor and said to the dredging contractor, who was dredging out some berths in a Navy yard, would you be willing, even though it's not part of your contract, to move your equipment and dredge this other berth way over there? Because we're going to be bringing in a new vessel for a christening, and we need to make sure that the draft is, deep enough to be able to handle that vessel. And, we're going to have some high up people coming in for this, and we want to put on a good show for them. So it would be very helpful to us if you could do that. And then, of course, we'll pay you for it under your existing contract. Well, the contractor said, the Admiral's asking me to do this and telling me to do it. Sure, absolutely, Admiral will be happy to do it. Well, this was not an inexpensive proposition to move this dredging equipment and to do this work. It was a healthy six-figure number to do it. Guess what? When the contractor tried to get paid, the contracting officer said, what are you talking about? I didn't authorize this. Where's the change order? Where's the written directive? Well, the Admiral told me to do it. The Admiral had no authority to tell you to do it. And much to our dismay, the Admiral was nowhere to be found and didn't want to back up what he said. We fought that thing for over a year. We eventually got the money because somebody realized that this wasn't right, but it all could have been avoided with proper documentation.
Yeah. Hey, Michael, can we stay on that slide real quick? I just want to make two quick points to the audience. One has to do with the purple prose. Michael's absolutely right. If you're using colorful language to describe particular employees of the government, it's going to be turned against you, and you're going to be characterized as someone who is disgruntled or has a bone to pick, and it's going to ultimately hurt your chances, pursuing certain claims. The other one that I think people need to be aware of is, look, if you have a verbal conversation of some importance with a government employee that might impact cost and time related to your contract, go back and put it down on paper and date it and memorialize it for the record. That will then capture that moment, even though there's no documented email exchange. And then the very last point I'll make on Michael's comment with respect to email strings, he's absolutely right. Be very careful on email strings. We see it time and time again where contractor employees will continue a thread that maybe has 7 preceding emails, and at the very bottom of that email might be a government employee. And everybody's just carrying forward the original audience. So you want to look out at who's on the addressee line, who's on the copy line, and just make sure that whatever you're talking about, one, it's appropriate, two, it's being kept in-house.
Thanks, Stephen. And you make very good points there. And I particularly wanted to just re-emphasize one of the things you said. Sometimes even though the contractor knows that something should be documented, you can't get the government to document it. Steve's absolutely right. Well, then you create the documentation. Send out an email and say, I just want to confirm that you told me today to do the following, and I told you, I'm going to do it. And then let them deny it. If they don't deny it, well, you've just created the document that becomes a record. So that's a very good piece of advice. Okay, many of the cases that come up and that end up in litigation and that we see in our practice involve differing site conditions. And as you know, the differing site conditions clause says that if you encounter subsurface or latent physical conditions that are materially different from what was represented in the contract, you're entitled to an equitable adjustment. That's called a type 1 differing site condition. Or if you encounter something that's different from what's normally found or in hearing and work of that kind, that's a type 2 differing site condition. Well, the differing site conditions clause has a very, very important notice provision, because the government can rightly claim that, well, what do you mean that you removed some rock in this excavation and you didn't expect to find any, and you did that 3 months ago? Why don't you tell us about it at the time? We might have told you that we don't want to spend the money to remove that rock. We might have redesigned the project, or we might have told you to leave it in place for some reason. I mean, you denied us in the government the opportunity to mitigate our damages. So you need to tell the government as soon as possible that we have encountered something that we believe is a differing site condition, and then the government has the obligation to promptly investigate it. And believe me, most of the time they don't, but at least cover yourself with proper notice. Now, sometimes the notice, even though it would have been better if it had been in writing, isn't provided by the contractor, but we find that there was constructive notice. And what that means is we can show that the government knew about it. What do you mean we didn't give you notice because we didn't write you an email message pointing it out? You were standing there when we were taking pictures and we told you about it and you acknowledged what you were looking at. Don't you remember? As a matter of fact, we wrote it down in a site report. So you can overcome the lack of a formal written notice with constructive notice. The important thing is make sure the government is on notice. And then be aware of the steps you have to take to prove a differing site condition. you have to show how you originally interpreted the contract, and you have to show that that interpretation was reasonable and that you relied on it. Don't say to the government, I didn't think that I would be encountering any rock. And the government says, well, then why did you bring in these backhoes and all this rock excavation equipment? So reliance is important. And then the most important part is you have to demonstrate that what you encountered is materially different from what was represented in the contract. There's nothing that the government fights any harder than a differing site conditions claim, because they take it personally. They feel you're telling me that I misrepresented what you would encounter. I'm insulted by that. What really happened here is that you just misinterpreted the plans and specifications. You should have known that you would encounter this, and we're not going to pay you for it. So be prepared to document very carefully what you encountered. Sometimes you might want to do some laboratory testing of the materials to show what was encountered. Got a project going on right now where a contractor encountered a great deal of trash and debris on a dredging project in the Hudson River. He did provide notice, but the government is now resisting paying for it because they said, what are you talking about? You didn't know that there would be a great deal of trash and debris in all places. The Hudson River, everybody knows you're going to run into this in the Hudson River. Well, the problem is the contract just only referred to some wood debris. That's it. A very brief phrase and reference. It didn't say anything about trash. It didn't say anything about an inordinate amount of debris that would stop the project and cost a lot of money. So we've told the government, you can't rely on what you think is general knowledge of the Hudson River. A contractor bidding a sealed bid procurement like this should be able to come in from Idaho or the West Coast and have very little familiar with the Hudson River, but be able to bid accurately on the basis of the plans and specifications because it's a firm fixed price sealed bid procurement. And I think we're going to win on that. And then, of course, you always have to show in a differing site conditions case that, when all these terrible things happen, that you actually were damaged by it and your damages need to be reasonable. But differing site conditions is something that you should pay a lot of attention to. And of course, what happens as well is sometimes the government will suspend the work, or there will be some sort of a series of events that lead to a suspension. And Casey, why don't you talk about that?
Yeah, thanks. I'll move through this one quickly because I know we've got a lot to cover here. But one common misunderstanding or failure on this front is misunderstanding the difference between actual and constructive suspensions. The actual ones are obvious. You're directed to halt work, put everything on hold for a period of time or for an indefinite period of time while the parties figure out some situation. But more often we run into the constructive suspensions, and those are ones that halt all work, not because someone has directed you to stop, but instead because no work can proceed until a submittal is approved, or until some design flaw is remedied, or until an RFI is answered. You simply can't perform work, or you can't perform a good portion of the work until you get some direction from the government. That's what the constructive suspensions work tend to look like. Notice is very important on this front. You can only recover costs reaching 20 days back from the time you provide notice to the government. So when you have that suspension in place, it's very important to provide notice. You're not allowed profit during that time, so it's a little bit different and limited in terms of the recovery you can make. And then finally, the recovery of extended home office overhead is probably the biggest misunderstanding on this front. The existence of a suspension is not enough to reach into home office overhead or extended home office overhead in this case. You have to have an indefinite period of time. You have to be unable to go secure other work, and you have to be required to come back at a moment's notice. So it can be tough to thread the needle to recover those costs, and it's important to understand the complexities with regard to profit, home office overhead, in the context of suspensions of work.
Thanks, Casey. And then, of course, when you encounter any of the things we're talking about, differing site conditions, changes, suspensions, you're going to be asking for costs, and some of those costs are field overhead costs, not setting aside the overhead costs that may or may not be implicated. What about the field overhead costs, which generally you'd think would be recoverable? Steve, why don't you comment on that?
Yeah, sure. So look, when you were asking for extended field office overhead costs, you're limited. You have a choice to make. You need to take them as direct costs, which is the per diem, right? Your daily rate, or you take them as an indirect cost. But no matter what, you're limited to a single distribution base. And whatever base you choose, however you're going to treat those costs, it has to remain consistent throughout the entirety of the project. You just can't change midstream, and you can't have seek field office overhead on a daily rate on modifications and then come in with an REA later and try to recover them on a percentage basis.
Okay, thank you.
Yeah.
And then, of course, an element of any of this will often be delay damages, because you may not only have direct costs that you've incurred. Now the project has run over the allowable time under the contract, and you're asking for some damages for a delay. And sometimes the government just won't recognize it. They just won't extend the contract time. They're afraid of what it might lead to in terms of additional costs, and they'll tell you, well, we'll address that later, but they don't address it later. And we've had contractors that have come to us and said, well, you know something, we've had it. We're going to walk off the job because they're not paying us and we're losing money. I will always do my best, and so will the other attorneys in our firm, to talk a contractor out of that. Because if you walk off the job, then you are going to be terminated for default, and you're going to be fighting a very uphill battle to turn it around. And even if you win somewhere down the road, that's going to be a very costly victory in terms of the time, the legal expenses, and what may happen to you in terms of losing other projects because you have a termination for default on your record. We had a contractor one time who was seriously delayed because he just wouldn't accede to the wishes of the administrative contracting officer. Still remains one of the most outrageous cases I've been involved in. This administrative contracting officer told the contractor that a certain metal building that had to be erected as part of the project work needed to be procured from a company that it turns out was owned by the ACO's brother. And he went so far as to say, and if you don't use that particular metal building from this company, well, then I don't care what you submit, I'm not going to approve it. And I'm not going to give you any additional time. And that's the way it's going to be. So you either use this or run the risk of being terminated for default. I still can't believe that this ACO thought he could get away with that. And I'm happy to tell you he didn't get away with it. We reported it up the chain of command, and we found out that this guy was not only removed from that position, he was suggested, he should have probably been court-martialed. He was a military officer. It was suggested that he resign, and he did. You can also run into situations that are cardinal changes. A cardinal change is a change when something happens that is so different from what was expected or required by this contract that you never saw it coming and you don't want to do it. Maybe you're not even able to do it. I represented a contractor one time who was building a parking garage that was attendant to the federal building in downtown Los Angeles. He was told that the underground portion of this garage had to be waterproof. Well, it turns out there was an aquifer and flowing water. And when he spoke to vendors and subcontractors who did waterproofing, they laughed at him and said, "What are you talking about? There's no way to make this thing waterproof." Not only did he find out that there was water flowing under there, but it was contaminated. It was carcinogenic when tested. So now you have a situation where the government is insisting that you do something that can't be done, and in addition to that, creating a hazard to the workers and perhaps to whoever ends up using that garage. So we asked for a termination for convenience. The government said no. And I was at a meeting where they were refusing to do anything. And I said, okay, fine. If you want it to become known in an article that will appear in the Los Angeles Times that you and this, the agency on this case was the General Services Administration. The GSA has no concern about carcinogenic water flows under its buildings, and will not only remove the requirement to make this garage waterproof, but will also refuse to do something to find out what can be done to treat this hazardous material. I'm sure that'll make interesting reading in the newspaper. And they asked for a timeout, and about a half hour later, it came back and said, okay, we're going to terminate the contract for convenience, which was the right thing to do. I know that somebody else ultimately finished that building and that parking garage, and I don't know what happened. I'll tell you one thing. I've been in that federal building a few times, and I don't drink any water out of the water fountains. And I would suggest that you don't either. We got a lot of questions, as you can imagine, over the last year or two about delays that related to COVID-19. It's unfortunate, in many ways unfair, but the government has taken the position, as they can do under the terms of the contract, that delays related to a pandemic or an epidemic entitle you to a time extension, but they are not compensable. Once in a while, we have found a contracting officer who is realizing how unfair it is and has granted contractors compensation, but don't count on it. It's a difficult recovery to make. In any of these things, regardless of the type of claim that might come up during performance, think about, am I going to someday have to not only present a claim, but possibly go to a trial or before the board on this claim? How am I going to establish that I'm right and the government's wrong? Well, many contractors are very expert in what they do and might even qualify themselves in some cases to be expert witnesses. The trouble is they're not truly objective because they're the contractor. So the best thing to do is to engage an expert early on. And I'm talking about if it's a differing site condition and it has to do with a geotechnical issue, get a geotechnical expert who would be prepared to testify if necessary. And the reason I say engage him early, give him the opportunity to view the site, to see what you're seeing, to take tests if he needs to, because one of the worst things that can happen is for an expert to come in and say, oh yeah, I was hired to look into this. Did you ever visit the project? No. When did you first find out about this? Oh, a year after the project was over. So you're telling me, Mr. Expert, that you had no opportunity to firsthand view or test any of the things that we're talking about. And if the expert says yes to those things, I didn't, well, it weakens his credibility. So get the expert if you need one in early. And you certainly don't want your expert to appear to be a hired gun. And by that, I mean someone who's hired a couple of years after the fact to come in and support whatever it is that you're saying. And above all, make sure that the expert is qualified and articulate. You know, in order to testify in court as an expert, the other side can ask questions to demonstrate whether or not you're qualified, and they will try to show that you're not. It'd be good to show that you've got some college education in this field. Be good to show that you've worked in this field before. And if you're a geotechnical engineer, to talk about some of the types of projects you've been involved in, hopefully some of them similar to this one. And above all, to be articulate. By that, I mean, be able to get on the stand and explain yourself in a convincing way. I one time hired, the contractor actually hired a geotechnical expert who I must tell you, I know was one of the foremost geotechnical engineers in the world, an extremely impressive individual. And I prepared him to testify. His expert report was excellent. And we went over what his testimony was going to be. And I put him on the stand. And I don't mean unkind. He came off as a bumbling idiot. He was nervous. He was stammering. He forgot what he was supposed to say. He was nothing like the person I had seen and interviewed and worked with for months before. And he realized it. And afterwards, he said to me, Mike, I'm sorry. I know I didn't do a very good job. I really get nervous when I have to testify. Oh, okay. Well, thanks for telling me after your testimony is over. And that's somebody, and even though I respected him greatly, I would never use him again because he didn't help the case. Okay. And, above all, in any of these things that you do, avoid a termination for default. Casey or Steve, you run into these things all the time. What advice can you pass on?
Yeah, so I'll move at a quick clip here just because of the timing issue. So yeah, first of all, look for, understand the warning signs. The more letters of concern you're getting from the government with respect to timeliness or quality of your performance, things of that nature, understand the government is preparing the record, okay? First flag. Yes, the government likes to make threats about liquidated damages and possible termination because they're trying to move you along. Whether or not they're going to move forward with it, we don't know, but you don't want to take the chance. Look, when you get a cure notice, you get a show cause letter, take them seriously. Read them, make sure you understand them, and in your response, address every point that is brought up. Don't leave anything hanging in the wind because the government will seize on it and say, great, you've addressed 4 of our 6 points. The other 2 are very serious. You haven't responded. We take that as an indication you're not prepared to overcome it. So again, detailed response, make sure you hit every point. And that bottom bullet point goes without saying, you want to avoid determination for default at all costs. It's the death knell for many contractors because it can lead to a potential suspension and debarment actions. So take all that stuff seriously. Casey, anything else?
I mean, even if it's unfair what's happening, or if it's frustrating, or even if the government's wrong, you still really need to bend over backwards in that scenario, because as Steve alluded to, it's much easier to deal with that annoyance and frustration on the front end than try to unwind it after a T for D has actually been issued. So it should be whatever you can do to avoid that scenario is worth your while.
Right. And last point, respond timely. If you need more time, usually you get 10 days. If you need more time, right out of the gate, you should ask for it, but don't depend on it. Prepare to move forward. Like, you're going to have to respond within those 10 days. If you get additional time, great, it's a positive. Otherwise, be ready to have that letter, that response in within the time frame.
Good points. Now, a very important subject, of course, is what happens when there's a release. And one of the first things that we do when we are presented with modifications that a contractor has already signed, we like to look at them before the contractor signs them. We look to see, is there a release? And Casey, you've been running into that situation quite a bit. What are the warnings here?
Well, if we have a client that comes to us and says they have a potential claim, one of the first questions we ask is, were there any modifications and were there any releases contained in them? And I almost cringe when the response comes in via email, because more often than not, there are some problems that arise here. And it's alluded to here, it's because every modification the government issues, and we're talking about bilateral modifications in this case, includes what's called a closing statement. It's not a closing statement. It should be called a closing statement to defeat all of your claims or to waive all of your rights. But it's simply a statement at the end of the modification that says this covers anything and everything that is known or should have been known or may happen in the future that's contained within the scope of this modification or related to it. They're extremely broad. And by signing those, more often than we would like to admit, contractors are waiving or releasing claims that really shouldn't be encompassed within the modification. They amount to an accord and satisfaction, and a judge will look at them to say that you release the claims that you'd like to bring now, and those claims are therefore defeated. So when you get that bilateral modification in front of you, make sure you read the closing statement, the scope of what's described, and as alluded to in the PowerPoint here, reserve your rights on the face of the modification or in an attached document. So sometimes you'll have contracting officers that won't let you mark up the modification itself. Well, then attach a statement to it that says the contractor hereby reserves its right to pursue claims for X, Y, and Z, that those things are not covered by that release. If there was one piece of advice I could give people out of this whole presentation, this would be the point of emphasis, the biggest mistake we see people make.
All right, thanks, Casey, and an important point. And I'll never forget the time that a contractor came to me with a very sizable claim that seemed to have merit. And I mean, it was a multi-million-dollar claim that looked meritorious to me, until I found out that because early in the project he was concerned about finishing late and begged the government for a time extension so he wouldn't have to worry about it. The government gave him a time extension of many months in exchange for a release of all claims now and in the future. So he had waived his right in exchange for that time to file any claims, not only related to that time, but for anything that came up in the future. And that was enforceable. And it was a real shame. Okay. We've got a lot of questions in this day and age too about price escalation, because everybody knows about what's going on around the world. We have inflation, which is a little bit different, but we've also got price escalation because of the global supply chain shortages, supply chain shortages. And Steve and Casey, you've addressed a lot of those issues.
Oh, sorry, Casey, go ahead.
I was going to say it's a difficult situation because your standard government contract really doesn't provide a contractor much avenue for relief. So if you're entering into new contracts, you can help remedy that by incorporating the appropriate FAR clauses. But to the extent those don't exist, we had to get creative. We've looked to characterizing those inflation or escalation costs as really delay costs or associated with a different change. So if you can, there are ways to get around the issue and be creative, but it can be difficult, and it's really not a scenario that your typical government contract is teed up for your average contractor. And Steve, if you have anything else, go ahead.
Yeah, no, I know we're running late. So look, DOD had guidance put out, excuse me, in May, where they are taking a more softening stance with respect to contracts, for fixed price contracts going forward. They're not fully endorsing contracting officers working out price escalation clauses, but they certainly are opening the door to do so. If you currently have a firm fixed price contract, you're out of luck. Look, that didn't sit well with industry. Industry's pushed back. There's been a huge lobbying campaign with Congress. DOD is in the process of refining that guidance. We expect it to be out in the next week. And they're going to take a look back at those contractors who have fixed price contracts presently to see if there is a way to modify those contracts. Again, it seems to fall short of an outright endorsement to do so. But DOD, again, is taking a softer stance. And as Michael pointed out, this really addresses inflation as opposed to supply chain chokehold. So keep that in mind too.
Okay, we're nearing the end here, and then we try to keep these to an hour. I think we'll certainly be finished within 5 minutes. And we have a couple more points that I think are worth pointing out to you. And one of them relates to the Buy American Act. And the Buy American Act scares the heck out of me, because people that violate the Buy American Act can get into a lot of trouble. It can even be debarred. And as an attorney, when I'm asked the Buy American Act question, I worry about malpractice. I always worry about giving a contractor the right answer, but many times this is hard. And that's why I turned to Casey, because Casey has become, I think, the foremost expert. So Casey, why don't you pass on just a few key points?
Yeah, a topic near and dear to my heart, which makes me, I think, kind of a sick individual in some people's eyes. But a few points I'll make just to be quick. Failures I see here is one, failing to look at your contract and identify which particular clause applies. Is it the regular Buy American Act? Is it the Trade Agreements Act? Is it some other iteration of those things, an alternate? At the very onset of the project, when you get an RFP, one of the biggest failures you get is failing to actually identify which set of the requirements applies. Two is not educating all levels of personnel about the requirements. So sometimes you have maybe people in the home office or a chief counsel who's aware of what the requirements are, but your boots on the ground are totally unaware of this. And that doesn't give you this multiple levels of defense that you want, where maybe your home office is surveying submittals and information you get from subs and suppliers, but your people on the project can also look for made in China stickers and things like that. So it's important that everyone be on the same page. And then third one is just accepting conclusory statements from people supplying or subs on the project. Sure, yeah, it's Buy American compliant, and more often than not, those people are wrong. So failing to really dig in, get the appropriate documentation can cause a lot of problems as well. I could talk about this one for hours on end, but I think that's the 3 points I would make.
Good points, Casey. Thank you. Very important to have an up-to-date code of business ethics and conduct because the FAR requires it. If you get into a problem because a misguided employee does something wrong, you want to be able to show, in order to make sure that the company is not blamed for this misconduct or unethical conduct, you want to show that you have a code of business ethics or a code of ethics and business conduct. If you don't, then you run the risk that the government will say, well, you don't have an ethical culture. You're a company that doesn't even address the possibility that somebody could do something wrong because you don't tell them what those things are and you don't give them any training. So periodic training and a code of ethics is important. If you don't have one, I suggest that you get help in having one prepared. And then last, the Prompt Payment Act. Payment applications that you make, progress payment requests can be very important, and they certainly cannot be false, because if you submit in a progress payment, you're certifying that in the previous progress payment you have paid the subcontractors and suppliers who you requested money for. If that ends up not being true, well, then you just have made a false claim or made a false statement to the government. So it's very important to adhere to the requirements of the Prompt Payment Act and to remember that you as a contractor cannot be a banker of the government's money. And by that, I mean, if you do not intend to pay a subcontractor because that subcontractor, for example, has been doing defective work, well, the government's not going to require you to pay them. Certainly you can hold the money and say, look, until you do this right, I'm not paying you. What you can't do, though, is physically keep the government's money in your checking account. You have to tell the government, okay, we billed for this, you paid us. We are not going to turn it over because we need to assure that corrective action is taken, and we're going to return the money to you. That's the right thing to do. 99 times out of 100, the court or the government is going to thank you for that and say, okay, you hold the money in the meantime because it's too much paperwork to return it. But that's the right way to handle this. Okay, we've covered an awful lot.
And we have 3 questions, Michael. I'll fire through them quickly.
All right, let's deal with those cases.
All right, number 1, can you elaborate on the difference between Buy America and Buy American? I'll take that one. I don't know why these two things are named so similarly. It's as if someone wanted you to be confused, but from a very high level perspective, Buy America applies to transportation projects for the most part. It's supposed to be designed for large scale infrastructure. So you see it both in direct government buys, but often also in state and local levels with federal funding involved. It applies more narrowly to a smaller scope of products, but it is much more strict and requires 100% domestic content. Buy American, on the other hand, is a more broad reaching. It applies to most federal procurements. It's a little less strict. You usually only have to hit 55% domestic components, and the product must be manufactured in the US, but that's the difference between the two from a very general perspective. Okay. And again, it's something that could be elaborated on for hours on end. All right, the second one, how do you edit a partial release that allows a claim to still go through? Is there a statement you can add in that doesn't close off a claim that is in process?
Sure. Hey, Case, I can take this. So the great question. So yeah, we call them carve-outs or accepted language. Essentially what happens in one of these situations, and this is really goes back to the importance of maintaining a healthy relationship with your counterparts on the government side, is getting together, dialoguing about the particular issue. I think Casey mentioned earlier, typically what happens is the contracting officer will send over the modification for your review and signature. If you take exception to the release and you want to carve out a particular subject matter that you want to pursue later as a claim, then you would edit the language as you would, as you see fit to achieve that and send it back to the government. Essentially just becomes a wordsmithing game between the two parties. You want to make sure that you're staking your claim to keep that out of the scope of the modifications release language. And typically the government is very receptive to that. So again, it's just really dialoguing with it. And again, coming up with whatever language you want to make sure keeps the possibility alive to pursue that claim or issue later on.
Okay, good answer.
And the last one, looks like, Michael, you're going to handle this one.
Yeah, I'll take that one. Many government agencies will not include any overhead in delay claims, when directed delays are given. And then is there a way to legally include overhead at this cost can be quite expensive and long delays? Well, you're right. And I'm interpreting the question to refer to delays that are the fault and responsibility of the government. The government, will try every trick in the trade to try to get you to accept a lower number. And they may say to a contractor, look, we'll pay the field overhead costs, perhaps, or the direct costs that you may have incurred, but we're not going to pay any overhead. Well, that becomes a numbers game. If that's enough money that you want to get it now, you might agree to do that. But when you ask, is there a way to legally include overhead as this cost can be expensive? The answer is yes. You don't have to accept a settlement of a delay claim that's based on government responsibility without adding overhead, both field and home office, in some cases, and profit. And if the government agency tries to tell you that you're not entitled to that, they're just wrong about that.
Right.
Okay, listen.
Michael, let me just
Sure.
because your answer to that question, there's a connective tissue between the question about partial releases and languages like that. So I've seen it happen, and this is something, again, you want to be wary of, where the government will tell you, just as Michael said, well, we'll talk about direct costs, things like that. We're going to hold off on overhead or any directs for later. And that's all conversations that lead up to execution of the modification. And we will see contractors then sign a bilateral modification over the issue, not carve out the extended field office overhead issue, relying essentially on previous conversations. Well, once you've signed that modification and there's no carve out for that, you're facing an uphill battle now. Not to say that it can't be surmounted, but you've put yourself in a bit more of a bind because you've essentially released those claims in the release language and when you sign that modification. So if you're having those conversations and the contracting officer is saying, we'll deal with those particular costs downrange, make sure you reflect that conversation in the modification, either in the body of the release itself or in the accompanying document or email that you send in along with the signed modification.
Okay, good point, Steve. Thank you. Okay, we've gone a little bit over, but as Casey pointed out, we had a lot of material to cover. We hope that we've given you some useful information. We appreciate your attendance, and feel free to get in touch with any of us as questions arise, or if you think of something afterwards, we'll be happy to answer it for you. And as we said, a copy of the presentation will be made available, and we wish you all the best. Thank you again. Bye.